Good afternoon. This is the House Judiciary Non-Civil Committee meeting. We are here to consider 3 bills on the agenda. Let's begin with House Bill 370. Actually, hold on one second. May not speak too soon. Is Representative Cook here? Representative Cook, let's go ahead and begin with your bill. I hesitate to say that any particular piece of legislation is more straightforward than another, but may not have quite as many moving parts, and so we probably do well to consider that first. And welcome. If you'd go ahead and just give us an overview of the bill, and then what we'll do is we'll open it up to questions from members. We'll probably do a round there, and then if anyone wants to speak to the bill, we'll open up for public testimony at that point, and then we'll feel the posture of the committee at that point, and then move on from there. So the floor is yours, and thanks for being here. Thank you, Mr. Chairman. Thank you, members of the committee. Just to start, this is House Bill 315. The substitute I'm be working from is LC 211164S. This is pretty straightforward. There's 4 places in current code that essentially this would change. It would take the boating under the influence blood alcohol concentration from 0.10, which it currently is, to 0.08. That's simply all it would do. This change would put us essentially in it would basically just line it up with obviously our current DUI laws. Also, the BUIs for all of our surrounding states, North Carolina, South Carolina, Tennessee, Alabama, and Florida, all have 0.08 already, and we do share waterways with them, so it would also make that consistent as well. The changes that are actually made are on line 32, 66, 80, and 98. And as you see, that literally is just the crossing out of the 0.10 and putting in 0.08. 42 states in the United States already have 0.08 on the waterways. So we're kind of a little late to the party on that, but getting there. DNR, I've worked with them on this, and they are in support of this legislation as well. And like I mentioned, it was pretty straightforward. With regard to the substitute, there was with the change from 0.10 to 0.08, it required changing the implied consent. The change was needed just to provide consistency throughout the BUI statute, which is the only reason why we brought the substitute. So that's pretty much it. It's pretty straightforward. If any of y'all, I guess if this would be an appropriate time, I'll take any questions. Mr. Ramsey. I don't have any questions, Mr. Chairman. Appropriate time. All right. Mr. Cook, let me just ask you on the implied consent piece on line 86. I just want to make sure that we're completely clear. I think it's very straightforward. Bill, will you submit to the state-administered chemical tests of your designate which test that language in parentheses, that's existing language right now, or I'm seeing the head nod from council, so right. Okay, so we're not actually changing anything. Okay, I just want to make sure that we were clear on that. So no substantive change from where we are now, right? In terms of the actual wording. Okay, Ms. Abrams. Oh, okay. All right. Ms. Neal, was that you? Oh, okay. All right. All right, I see. Mr. Ramsey, did you have another question, or you wanted to? Just a motion at the appropriate time. Okay, thank you. Yeah. Okay, Mr. Cook, I think we'll excuse you. Okay. Thank you for your presentation. Very straightforward. We appreciate it. Thank you. Thank you for the committee's time. We'll go ahead and ask for any public testimony on this. I see William Woodall. William Woodall is signed up to speak on House Bill 315.
Mr. Chairman, I'll be real brief, I think.
Let me go ahead and ask you to sit in the
William Woodall
the hot seat and speak into the microphone, if you would.
With the Georgia Hunting Fishing Federation, I'll be very brief. We support the bill, and let Chairman Ramsey make his motion.
Thank you, sir. Is there anyone else who'd like to be heard on House Bill 315? Seeing none, let me recognize Mr. Ramsey for his motion.
I move do pass the substitute to HB 315 LC 211164S.
Motion by Mr. Ramsey of due pass of House Bill 315 by substitute LC 211164S. Is there a second? Second by Mr. Pack. Ms. Travis, let me ask you, just in your look at, I'm seeing just strikes on the BAC level. I see nothing else. Do you see any other issues that you've been able to identify just from a technical standpoint before we go to a vote? No. Okay. Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Cook. Let me recognize our Judge of the Week, Judge Emerson from Douglas County. Judge, where are you?
Good afternoon. Nice to be with y'all.
Thank you for being here to join us. We see the judges as a resource and hope you'll allow us to use you as a resource if any issue comes up in your mind as you witness what we do. There's a separation sometimes between the words on paper and what actually happens out in the world, and to the extent that you can go ahead and take your time and experience and benefit the process with that, we sure would appreciate it. And again, we
provide any help I can.
thank you, sir. We appreciate your being here. Let's go ahead with House Bill 373, Representative Pack. Mr. Pack, I see you have a special guest with you.
Yes, thank you, Mr. Chairman and members of the committee. Along with me is the Commissioner of Department of Juvenile Justice, Amy Howell.
Commissioner, welcome.
Well, thank you. I'm presenting House Bill 373 for the committee's consideration. This bill was requested by the Commissioner on Department of Juvenile Justice. A little history, and when I first looked at it, and I want to set kind of my thinking on it, and hopefully the canvas I guess I paint would kind of help you kind of focus on what we're doing here, because I think it's prone to kind of mischaracterization if not. I view, given my experience in the criminal justice system and law enforcement world, I view criminal law, there's three purposes, one of which is punishment and retribution, second is rehabilitation, and also restitution to the victims. In the juvenile context, although I don't primarily practice in this area, I believe because the youth and their naivete, that rehabilitation is one of the more important factors out of the three. And I think that concentrating our laws as a matter of public policy towards that goal is probably very important. The bill that I'm proposing today, at the request of the Commissioner, allows more flexibility to the juvenile judges to modify and also to fashion a more appropriate sentence for a juvenile in light of their changed behavior and good behavior. There's some technical things in here. Right now, as I read the statute, and they could correct me if I'm wrong on this, that the juvenile judges have discretion to modify sentences for change in circumstances and other factors, except for when they are committed to the custody of the Department of Juvenile Justice. And there's a statute here that's not being amended right now that governs that, and that has a specific exclusion for the juvenile judge's authority to modify a sentence based on change in circumstance. And the case law has kind of read the statute strictly to prevent the judges from modifying the sentence. So, for example, if someone is committed to a detention center, development center, youth development center, because they are adjudicated guilty of a designated felony that's defined by the statute, the juvenile judge, no matter how good the behavior of the juvenile, if all parties agree that this person has been rehabilitated, the judge lacks absolute power at all to modify that sentence to accommodate for the change in circumstance. That's what we're trying to correct with the House Bill 373. A couple of facts. I sent out a kind of a bullet point of certain things that we're doing with this bill, and I flagged a couple things for your consideration. One is that the department anticipate that if this bill is passed, that approximately 60 youth are, in fact, eligible to be considered. I also asked them for a breakdown of how much it costs to actually house these individuals, and it broke down to somewhere around $230 a day. By simple math, by not modifying or the judges not having the ability to modify their sentence and perhaps remove them out of the Department of Juvenile Justice system and custody system, that we're probably costing the taxpayers $13,821 a day. That's based on the 60 youth that we've identified today. As a public policy matter, generally I favor a juvenile judge, having more discretion in the fashion of sentence, probably because he or she is more inclined to know of the offender and the facts and circumstances surrounding it. As a legislator, of course, we want to control a lot of things, but I think as a lawyer and also someone who practices in the court system a lot, that I think it's very important that we give significant deference and discretion to judges to fashion an appropriate sentence. With that, I would like to turn it over to Commissioner Howe.
Thank you. We're really pleased to be here today to present this bill with a representative, and we were glad that he was willing to work with us. And I have to say that this was a bill that we worked on with the Council of Juvenile Court Judges on, so we're really pleased to have that agreement amongst the two entities. Representative mentioned the 60 youth that we identified that would be eligible. I will say that we have over 900 youth right now who are designated felons who are in custody. So the department often gets accused of only managing our budget and beds, and this is really an interest in the future influence on young people. It's not going to have a dramatic impact on our population right now. What we hope it will do is motivate those young men and women that are with us to begin to rehabilitate much faster than they would otherwise, and really take advantage of the educational, mental health, counseling, vocational training that's available to them, and also become greater aware about their impact on society and the potential to really reform and develop into good, solid public citizens. So our hope is for what the potential is moving forward, and we think that the juvenile court judges are a good location to bring these cases with all the parties to be able to weigh and present the evidence for the judges to decide. So we appreciate your support for this bill.
Mr. Pack, let me ask you, if you would, to walk us through the process. I think it's important for members and for members of the public who are watching, and then, of course, after the fact, should this bill become enacted, I think it's important for all interested parties, members and the people we represent, to walk us through the different steps, because I know that the different steps in the process include the involvement of a lot of different parties and assessments of behaviors, likelihood of a future problem, who gets notified and when, in order to make sure that we have everybody involved and everybody observing and having input into that decision. I agree with you. I think most of us do on providing more discretion to the judges, especially in a case involving a juvenile. That being said, we do want to make sure that from a process standpoint, the prosecutors are involved, victims involved, and of course, juvenile justice is involved as well. So I'm not asking you to read every line of the bill, but take us through the process in order to illustrate how that'll work.
Certainly.
Thank you.
If a juvenile is adjudicated guilty of a designated felony and the court has sentenced that individual to the custody of the Department of Juvenile Justice, the bill would start being triggered by someone who has been in custody for a certain period and starting to show good behavior. So at that time, there's what we're changing, first of all, is the juvenile judges having the discretion to modify the sentence, despite the fact that these juveniles are designated felons who are placed in custody of Department of Juvenile Justice. So when that happens, Department of Juvenile Justice or the juvenile's lawyer could obtain an affidavit and certain letters from the counselor who oversees the juvenile in support of evidencing good behavior, and they would file a motion with the court to modify the sentence. It's also the bill requires them to give notice to the prosecutors, and also at least 2 weeks notice to the victims, if any, of the juvenile's convicted offense. And then after that, the court, I imagine, although this is not spelled out specifically in statute, and then we do have a juvenile judge here, Judge Henry, who could shed light on actually the process of modification.
A key provision of the bill, lines 45 to 48, is that in addition to the parties of the motion, the prosecuting attorney and the victim shall have the right to be heard.
That's correct.
And I think that's a key component.
Right. So this is not an automatic thing. Just by filing a petition, you're going to get a modified sentence. It's all the interested parties have been given notice, and they are allowed to present evidence as the bill proposes. And once that happens, the court actually has to make specific findings, as listed here in line 56 down to 64, if in fact he or she decides to modify the sentence. And that includes important things like the needs and best interests of the child, the background of the child, the economic progress, the victim impact statement, and obviously the testimony and evidence presented by the parties, the safety risk to the community if the child is released, and the child's acknowledgement to the court and victim, if any, of his or her conduct being the cause of harm or the others. So it's a full participation by all the interested parties, and the judge has specific, I guess, the tools and also the evidence presented to find whether or not this modification is justified in the context. And the bill requires, if passed, that the judge make specific findings weighing those factors I outlined for you.
And it cannot occur earlier than 1 year of custody, is that correct?
That's correct. And they can't petition repeatedly. They have to wait once every 12 months is the limit that they could petition.
Okay. Questions from the committee? Mr. Setzler.
Thank you. And I'd like to congratulate the Commissioner on her role.
Thank you.
You've been coming to this committee for a lot of years, and it's exciting to see you in this.
Thank you.
So,
Thank you.
I think I remember you were first representing the department as an attorney.
Yes.
What, 6 sessions ago or so? So,
About, yeah.
congratulations.
Thank you.
To the author, actually, let me direct the first question to the Commissioner, if I could. What's the process that's followed to determine good behavior? Is that a systematic process to make that determination? And could you share that with the committee for us?
Sure. If this bill should be passed, we would set up a process and policy that would lay out how that would procedurally happen through the system. But I can tell you things that we would be looking at is their disciplinary history in the facility, whether or not they have been involved in any incidents in terms of breaking the rules, any sort of violence. Those would be very key factors for us to determine whether or not they would be eligible for a recommendation. We'd be talking to teachers and their counselors about their progress and their behavior, also with counseling to get a sense of whether or not accountability in relationship to acknowledgement about what actions they've taken and responsibility for them. So it would be a multi-system evaluation of their progress.
Okay. How do you anticipate, and this is perhaps a question for the author, how do you anticipate the right to be heard by the victim? Is that going to fall in line with other parts of the law where victims are able to present their testimony? Are there, in juvenile court context, are there other cases where victims can present to the court in a way that we're just tapping into an existing practice?
Yes, actually, the victim rights kind of statutes that Georgia has governs the rights of victims to present evidence. Actually, you can't deny them the right to be heard. And the intent, obviously, is to follow those protocols that exist. Is
there a tight, I know we just passed an update to the evidence code and some of these, I don't know if that impacts us at all. Is there limitations on hearsay and being able to share opinions, or are you limited to just facts? How would that play out in this context?
Generally, on hearings such as sentencing, the evidentiary rules do not apply. So you can present hearsay. You could do it by letter, the confrontation clause, those type of issues that are the protections that are in a trial will not be present. So that also frees up the juvenile judge to take in the holistic approach to seeing the case. So there's no exclusion of certain evidence that's viewed as irrelevant. The judge can certainly consider those things in making his or her determination.
So there's not a statutory or otherwise procedural prohibition from a judge allowing, you know, a hurting family member to come in and really just kind of tell their whole story to the court and show emotion. That's still going to be possible here to kind of help balance this.
I would fully expect that to happen. Matter of fact.
Ms. Abrams.
At the appropriate time, I'd like to be recognized for a motion.
Certainly. Any further questions for the author or Commissioner Howell? Has a good ring to it. Seeing none, let me ask Judge Bryant Henry of the Juvenile Court of Walker County is asked to speak on the bill. And Judge, thank you for joining us today. Let me just make sure, just for our edification, are you speaking on behalf of yourself as well as the Council of Juvenile Court Judges, or if you could just clarify that for us?
Actually, I'm speaking on behalf of the Council of Juvenile Court Judges.
Excellent.
And if I speak on behalf of myself, I'll try to identify that and distinguish that.
That's fine. We just, we want to make sure that we're clear, and because we take judge organizations' opinions seriously, and we also take individual judges' opinions seriously, but we'd like to know exactly how that's being presented, and it helps us formulate our decisions. If I could ask you to move a little bit forward and speak into the microphone. Thank you.
I appreciate you recognizing that distinction, because it is an important distinction. And I appreciate the opportunity to come down and speak with you about this bill. I am Bryant Henry, the Juvenile Court Judge in the Lookout Mountain Judicial Circuit and current President of the Council of Juvenile Court Judges. This bill came about really, I guess, through some collaboration and discussions with the Department of Juvenile Justice and the Council of Juvenile Court Judges, and I want to express my appreciation to Commissioner Howell for hearing the input of the judges on this. Our council does support this bill. Let me just take a moment. It may help some to understand how we get to this point, to understand the need for it. A designated felony is one of the more serious charges, delinquent charges that we have. When a child is adjudicated to have committed a designated felony, and these are things like aggravated assault, arson, robbery without a firearm, some of the more serious things, battery on a school teacher, those kind of things. But after we have an adjudication, then we have to have a disposition hearing. At that disposition hearing, if the state is seeking restrictive custody, which is a detention type disposition, the law requires that we consider a number of factors. Those are the needs and best interests of the child, the record and background of the child, the nature and circumstances of the offense, the need for protection of the community, and the age and physical condition of the victim. After hearing that evidence, if we determine that restrictive custody is necessary on the first offense, first designated felony offense, we're required to place the child in restrictive custody for a minimum of 12 months. Commit them to the Department of Juvenile Justice for 60 months with a minimum 12 months secure detention. If it's a second designated felony offense, then it's a minimum detention of 18 months. The problem that we have is that once the child is given restrictive custody, and this has been addressed, there's really no provision in the code now that lets us release a child early that has been rehabilitated. And that's what we're all about. That's what juvenile courts are all about. That's what the mission of the Department of Juvenile Justice is all about. So after some cases identified that omission, then that's the purpose of this legislation. And when you've got a child who's done well and has been rehabilitated, to leave that child and further, say they've got a 3-month secure detention disposition, if they in 18 months, if they've recognized the error of their ways and they've done well academically and they've stayed out of trouble and acknowledged the impact that their behaviors had on the victim, then it's counterproductive for a number of reasons to keep that child in secure detention. One is that you're running the risk that being there with 900 other designated felons, that they're going to be influenced and fall back from the progress they've made. In addition to that, it's just not right. It's not right to keep a child who's been rehabilitated and ready to come back into the community in secure detention. And it's certainly not fiscally responsible to do that. So I think there are a lot of factors that need to be considered. Another thing that I think is good is that when a child sees that they can be released early, it's going to motivate that child to pay attention to their academics, to stay out of trouble so that they can possibly get released early. And I'm sure all that will be explained to them when they first come in, that they'll have that hope. And if they don't have that hope, then there's really no motivation for them to behave themselves, I guess, while they're there. Certainly, the fiscal side of it has been explained, and I think that's clear. As I went over the things that were required to consider when a child gets restrictive custody, this bill incorporates the kinds of things the judge can consider in whether or not to release a child from secure detention. And all of those are important factors, some of which I've mentioned. But it lets us also, you're looking not only at the rehabilitation of the child, but also the safety interest of the community. And I think that's important. For this decision to be made by the local juvenile court judge, you're having someone who's familiar with the child probably and the history of the child. One of the important things when a child comes out of restrictive custody where they've been in an extremely structured environment is as much as possible to make sure that that structure is going to continue and services be received by the child once they get out. This lets the local juvenile court judge, who's familiar with local services and family resources, to assess that and come up with a plan to make sure that that child is going to get as much structure back in the community and support as they had before. We think it's an excellent bill. We think it's needed and it's appropriate, certainly for juvenile court.
Thank you, Judge. Any questions for Judge Henry? Seeing none. Thank you, Judge. We appreciate you taking the time to be here. Ms. Kirsten Widener.
Thank you, Mr. Chairman, members of the committee. My name is Kirsten Widener, and I'm the Director of Policy and Advocacy for the Barton Child Law and Policy Center at Emory University Law School. And we're one of 3 partners in an organization known as Just Georgia, which, as you may know, has been working for many years on the Senate side on a rewrite of Georgia's Juvenile Court Code. This touches that code, and so we have a very specific interest in it as it relates to that work. And so we just wanted to let this committee know we view this bill as being very consistent with the reform efforts that are going on around the juvenile code in principle and in language. And in fact, we had incorporated an earlier draft of this bill into the current version of that bill, which is SB 127. So we're here to voice our support and see this as a great step in the right direction for recognizing that children are individual in many respects, and that needs to be considered in thinking about how long they should be serving time for their crimes. Thank you.
Questions from Ms. Widener? Seeing none. Thank you. If I'm saying this wrong, I apologize. Jovan Bazan, is that correct?
Thank you.
That was close. Very close. Thank you.
If it was a square, you would have almost got it.
Welcome.
Thank you. Good afternoon, everyone.
If you could pull the microphone a little closer to you. Thank you.
Is that better? Is it? Okay.
My name is Giovanni Bazan. I'm 20 years old. I'm a youth advocate, or an advocate for youth. I currently work for the State Office for Department of Family and Children's Services at the youth as a youth support specialist, and I also work for an organization called Georgia Youth Empowerment, which is a program of the Multi-Agency Alliance for Children. I want to talk about, of course, the Good Behavior Bill in regards to my personal experiences. Initially, I started out in foster care and then went into DJJ system at 12 years old due to running away from an abusive home. So during my experiences in DJJ, ultimately my recalcitrance led up to me having a pocket knife at school, for which I, of course, is a designated felony in Georgia, and of course I had to do the minimum restrictive custody of 1 year or 12 months. Having made this decision, this very poor judgment on my behalf, having an entire year to learn about, to understand, the detrimental aspects or the detrimental consequences of my actions, was more than enough time. Was a mere travesty, to say the least, to keep me detained for that period of 12 months when clearly, it was a mere in the moment misjudgment on my behalf. To be restricted for 12 months was an atrocity. It caused me to, of course, as far as academics is concerned, it's very vital to keep that child consistent and current with their current education as it relates to where they're from, what school they normally attend, and the curriculum that they follow. So for me to be separated from that curriculum and from those academics, and to be have to follow this new curriculum in the DJJ system for a period of 1 year, it completely alters not only the learning process, it completely alters the curriculum, and it proved to be extremely detrimental. While in high school, when I came out, I joined ROTC, and of course I excelled through the structure of the ROTC program, but because of my detainment, because of the amount of time that I had been detained, school records, as I went back and I applied for the ROTC scholarship, and as I was a candidate for the United States Naval Academy, I was unable to receive entrance because, in large part, because of the lack of academic records that were able to be provided, and that's consequently as a result of me being detained for 12 months, going from transferring from the local RYDC to the longer-term Millersville YDC. And had I not been in there for such a long period of time, then my academic records would still be readily available to the United States Naval Academy. Also, as I pursued a post-high school career, once my United States Naval Academy was turned down and ROTC scholarship was turned down, I pursued the DeKalb County Police Department, Atlanta Police Department, United States Army, United States Marine Corps, and I was turned down for those as well because of my having served over 12 months. The specific one of the specific questions that they ask on the actual application per se is that have you ever served 12 months due to a felony? And of course, if this bill goes through, then of course that can be the juvenile court judge, contingent upon the juvenile's behavior, they will be allowed to release the juvenile previously or prior to their 12-month sentence or minimum requirement, which is I'm in complete support of, because I think as Judge Henry hit it best, the mission of the juvenile justice system, of course, is to protect and serve the citizens of Georgia, and it goes on to talk about how we want to hold the youth accountable, but at the same time provide them services so that they may rehabilitate and so that they may become productive members of society. Well, we're doing them a disservice, like just to reiterate what Judge Henry said, we're doing them a disservice, we're doing ourselves a disservice by keeping these youth who are already, as an adolescent, they're already impressionable. So if you keep them for an extended period of time in a facility that, is predominantly filled with all these negative behaviors, for someone in my circumstance who just made one bad mistake, I became influenced by all these other behaviors, which was detrimental to me over that long period of time, where alternatively, had I just had the juvenile court been able to deem that I would have been rehabilitated within that 3-month period of time or shorter or whatever the case may be, then I could have been well on my way back to high school. I could have been on my way back to other venues of career choice of United States Naval Academy and so forth and so forth. So I just want to say I am in strong support of this, and I definitely hope it passes. So thank you.
Thank you, Mr. Bazan. Is there anyone else who'd like to be heard? Seeing none. Mr. Pack, did you have something? Or did you? No. Okay. Oh, I'm sorry. Mr. Atwood.
Just one question. Can you hear me?
Oh, I'm sorry. Did you have a question for our previous witness?
I just had a statement to make. I spent 34 years with the Marine Reserve, retired as a colonel. If you'll get with me after this, if you're still interested in the Corps, if I can get your sideburns a little higher, I'll help you. Okay? Come see me.
I would take that seriously if I were you. Thank you, Mr. Atwood, in more ways than one. No one else has signed up to speak. There's no one else like to be heard on it. What's the pleasure of the committee? Ms. Abrams?
I'd like to move do pass HB 373 LC 294575.
Ms. Abrams moves do pass House Bill 373 LC 294575, second by Ms. Randall. Is there any further discussion? Are there any amendments? Seeing none, all in favor of the lady's motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Pack. We'll go to House Bill 390, Representative Coomer. Mr. Coomer, the floor is yours.
Thank you, Mr. Chairman. Let me just start by making a statement generally and then kind of getting into the meat of 390. In any non-final order in a criminal case, other than an order suppressing evidence, the appellant has to get essentially the permission of the trial judge to file an immediate appeal from that decision. And that decision is in the form of a certificate for review, in which the judge clarifies the importance of the decision and the appropriateness of that immediate review. House Bill 390 would clarify that an order granting a new trial is in fact a final order, and that is an appealable order that may be taken, appeal may be taken from that order without the judge certifying the necessity of that immediate review. This is a fiscally responsible provision in that it saves taxpayers the expense, time, and delay of a new trial when, in fact, a new trial should not be granted. And in those situations where the new trial order was entered in a manner that disregards the facts of the law applicable to the case, or is entered by abuse of discretion or judicial misconduct, I would say the prosecuting attorney's counsel is supportive of this bill. I have talked to Superior Court judges individually in my circuit and around the state, and as representatives of the Superior Court Judges Council, and there's no opposition from the council, and I've heard minimal concerns from the Superior Court judges I've talked to, and been able to allay those concerns with discussion and explanation of the bill and its intent. In addition, I would add that the Southern Center for Human Rights, which is a death penalty defendants advocacy organization, has also reviewed and expressed no opposition to this bill. So I've got feedback from prosecutors, defenders, and judges, none of whom are opposing this bill. So I would ask the committee to support the bill and send it on to the floor, or the Rules Committee.
Questions for the author? Seeing none. Ken Malden is the DA of the Western Circuit. He also represents the District Attorneys Association. District Attorney Malden, would you like to? I see you signed up for.
Yeah, I'll be brief.
390. Yes, sir.
Mr. Chairman, members of the committee, I'm Ken Malden, the DA in the Western District Circuit, and serve as the president of the DA Association this year, and this was one of our priorities, and we would urge you to pass this matter. I believe it is for any number of reasons, particularly because it's fiscally responsible. If in fact you appeal a matter and the appellate court agrees with you, you don't have to try the case and go to the expense of actually trying that again, but you at least have that opportunity to consider whether to appeal it, and if so, and if you're successful, then you would say that. If not, then you would actually try it. So that's all I would have to say.
Any questions for the DA's Association from the membership? Mr. Willard.
Thank you, Chairman. This morning, I've got in the file the State versus Ware case. I have not, and I assume this is put in as a part of the support of need for the change in this particular bill.
Yes.
What was, I haven't had a chance to look at it and read it completely, but what was the Supreme Court's justification in looking past what was done in the 2005 Act?
I can answer that, but Don Geary from the DeKalb DA's office is here, who actually handled that matter, and I think he did sign up to speak, and he may be the best person to answer that. If that's all right.
Let's call Mr. Geary forward to continue that line. Mr. Geary, welcome. And did you hear Chairman Willard's question?
I did also want to say hey to Colonel Atwood, having served in his squadron for many years. I want to say hello.
Oh, we definitely want to get with you after this meeting then.
It would take longer than you have, sir.
Oh, that's a telling statement, Mr. Atwood. That's very telling. But if you could address Chairman Willard's question, that would be wonderful.
I will, sir.
Thank you.
That case was a individual arrested, tried, and convicted for the murder of a child by 12 jurors without, and I mean no criticism to the judge, but the judge expressed a dislike for the facts of the case, even though the jury said what the jury said. The judge granted a motion for new trial.
To the defendant?
Yes. Did not grant a certificate of review.
All right.
We appealed anyway, begging for an opportunity. We got none because the difference between 571 and 572, it had to be discretionary. We had to get the certificate. We didn't get one.
Okay.
We asked anyway. The court said no. The way the law reads, you must get it.
I remember now. We did make that provision, as I guess applies also to civil cases on a motion new trial.
But the reality of it is, though, the smallest piece of evidence can be suppressed, and it can be litigated for years. But you can get a decision by 12 jurors holding someone guilty of murder, and a judge with a wave of the hand, again, no respect. But if judges were always right, we wouldn't have appellate courts. But by a wave of the hand, they can throw out a jury verdict and prevent it from ever being looked at by another court. And all we're asking for by this is the basis of our system, equal protection for the victims as well as defendants. Just put another set of eyes on it. And whatever the outcome is the outcome. But at least, like everything in our system, it gets another look, it gets a review, and we try to do the best we can for everybody.
That's all I have. Thank you.
Any further questions for the prosecutors? Seeing none. Gentlemen, thank you. Is there anyone else who'd like to be heard on House Bill? I don't have anyone else signed up to speak. Is there anyone else who'd like to be heard on House Bill 390? Seeing none, what's the pleasure of the committee? Mr. Ramsey.
I reshuffled my papers and I don't have the there it is. Mr. Chairman, I move do pass HB 390, which is LC 294615.
Mr. Ramsey moves do pass House Bill 390, LC 294615, seconded by Mr. Pack. Is there any further discussion? Are there any amendments? All in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Coomer. That concludes our agenda for today, and we are adjourned. Thank you very much.